Court rise if able.
I'm sorry we haven't made a clean start. Partly was someone wanted the water supply filled up, but anyway, here we are.
Thank you very much, my lords and my lady. With your approval, there's been a discussion about the allocation of time. I will take another 10 minutes or so, subject, of course, to be told that it's unhelpful.
Can you speak up a bit?
I will take another 10 minutes or so, subject to your indication that it's unhelpful. Mr. Chewan will be about 20 minutes. Mr. Lamb is content that...
Ms. Ewell isn't speaking.
Miss Ewell is going to speak. I'm so sorry. She's sitting behind me out of my eye line. Quite inappropriate for me to forget.
Well, she'll speak after Mr...
She will, and she'll be about 10 minutes. And then Mr. Lamb has indicated he's content that that will leave sufficient time for his contribution.
Right, well, let's get on with it. I'm
we'll
sorry we lost 10 minutes at the start, but if necessary, we can perhaps sit a little bit later. But off we go, but I think I need to hold you to 10 minutes.
Very well, my lord. So, my lord, I'd like just to make, I think, 3, possibly 4 points. The first is about our criticism of the structure of the judgment. And this we align with some case law in the authorities bundle. I'm going to ask your lordships to have regard to paragraphs 33 to 38 of Re S. That's at page 189.
Well, do we need to see? All right. If it's a good point, does it need us to go to all the authorities?
No.
What is the point?
Not. The point is that the judgment has suffered from being structured as an account of each of the witnesses' evidence, which means that it lacks the full. It lacks the analysis of weight that we referred to before.
Okay, thank you.
And that, as I say, is supported by Re S. My Lord, just a short point. His Lordship asked if there was guidance as to how allegations should be managed by school professionals. For this, we have a reference in the case of AS and TH. For your note, if it's any help, it's at page 204 of the Authorities Bundle, paragraph 41, where it is stressed that the importance of proper recording of everything that has been asked and
I think we know all that,
is underlined.
Well, that's specific to schools, is it?
It refers to schools.
I'm aware it's generally true with social workers and so on, and the police, but this is specifically about schools. Let
me please just be absolutely sure that I don't mislead, because I certainly have no wish to do that.
Okay, well then we better look at it. Page 196.
If we please go to page 203 of the authority.
Yeah.
There is reference there to the departmental advice, what to do if you're worried about worried a child is being abused, and that's the starting point before referring to.
Yes, well, I mean, all this we know. My Lord was asking simply a particular question about whether this applies to schools.
It does.
But that's not clear from the authority. But you just say.
Well, it applies to professionals taking information before referring to children's services or the police. So any professional who is taking information of this nature, making a MASH referral, such as DL made.
I'm not saying you're wrong, but what's the paragraph that helps us on this point?
Well, I would say paragraph 36.
Okay.
35 as well, 35 and 36.
Thank you.
So then just moving please to one other issue on the substance of the evidence. At Core Bundle 468, paragraph 9.27, please. This is part of Dr. Powis's psychological report, information obtained from CL.
Do you want us to read it?
Please.
Yes.
This links back to the points already made about the lack of proper recording. Here we have evidence of unmediated conversations with A, not written down.
So who's having the unmediated conversation?
CL.
But this is Mr. Paris's report, isn't it?
Yes, these are reported to Dr. Powis
By
by
whom?
CL.
By
CL.
I see, thank you.
And there's no other evidence from her in relation to any such conversations with A.
So where did the judge go wrong?
Well, one feature of
Did
this...
the judge refer to this passage?
She refers to CL... She refers to CL's evidence, and
But does she refer to this passage?
Yeah, she takes from it support for a finding that well, she doesn't take it from here. She relies on the she alludes to this evidence. She refers to the oral evidence and says it supports a finding of fingering.
But I'm sorry, why are you showing us this you're trying to show us areas where the judge went wrong.
Yes, what she
I
doesn't...
assumed you were saying the judge. Why is this relevant to what the judge did wrong if the judge didn't refer to it?
It chimes back to the point that was being referred to earlier in our submissions about whether what the judge didn't tackle is the information here that apparently A to CL was also again making allegations of contemporaneous abuse as well as historic abuse. So there are a number of problems here, unmediated conversations, unrecorded and inconsistent with what was said to TC. The danger of unmediated conversations is well known to the court.
If you're on borrowed time, just make the point and move on.
Very
Unmediated and unreported conversation.
So we link it to paragraph 94 of our skeleton.
Yep.
The bold finding by the judge that it's neither possible nor necessary to put a date on each of the incidents of sexual abuse. I am satisfied they'd happened as A described to others. Well, the fact is there is, as we've already submitted, a multitude of accounts, if not a multitude, then a number of different accounts, which the judge has failed to differentiate, does not properly analyse. So a simple finding that abuse has happened as described to others is, we say, insufficient and inappropriate in that context. So that's all I'll say, my lord. Thank you for the additional time.
No, thank you very much, Ms. Howe. That's been very helpful.
Thank you.
Yes, Mr. Stewart.
Thank you, my lords, my lady. Two of our grounds of appeal may not be necessary for me to address at all.
Although those are the ones about the finding of fact the judge didn't make.
They are. My learned friends have concluded and confirmed to me today what they say in their skeletons, that they say we're just misplaced in saying that that finding was made. It was an honest reading of the judgment by me, not at the trial, but I'll say no more about it. If it's not up to my learned friends, it's up to this court. If this court is satisfied that that is not a finding made, I don't need to attack it.
Well, that was certainly my understanding. I can't. This is the finding.
Deliberate pressure.
Yes, exactly. There was a finding, as it were, with a small f, which implied that to some extent.
Yes.
But that is not a finding that is one of the ones that she makes at the end.
I agree.
And that's the latter that matters.
I agree. If we've read the judgment too pessimistically on behalf of our client post-trial, I apologise.
No,
We'll
no need for
jettison it.
apologies. Courts never mind when you abandon points.
So there are 2 points left.
Yeah.
Grounds 2 and grounds 4. Ground 4 is really it, failure to protect. But ground 2 as well, reversal of burden of proof.
Yes.
They really go hand in hand, and I'll deal with them on that basis. Can I make a generality first?
Yep.
And then go, I hope, quickly to specifics?
Yep.
It is difficult to read this judgment as an assessment of witnesses. A is a witness. Whether or not she attended to give oral evidence, she is a witness, and her evidence must be approached on that basis, and the judge fails to do so. The judge fails to balance the lack of cogency of primary allegation with the cogency of the retraction. Now that relates to my client, who's neutral on on the allegations against the stepfather. That relates to my client in relation to the failure to protect point. And it relates because, in a general sense, but also for these specific reasons, the timing of the serious allegations made is very different on the evidence as it is to the judge's conclusions. By which I mean, in 2017 or 18 or 19, there are the findings of kissing, of sibling touching, and of patting the bottom. The much, much more serious finding, alluded to and referred to directly by this court this morning to Ms. Howe, of the licking of the penis, is in 2022 on the papers. Nowhere...
Wait. The allegation. Was
the allegation.
Yes.
Nowhere on the papers is that earlier. It arises because of the stepfather's evidence, oral evidence, that he thought that was earlier. The judge deals with this by starting to say at paragraph 156 of the judgment, the learned judge says, that's page 94, the stepfather's not a truthful witness. Forgive me, I'm not trying to find. I did not find the stepfather to be an honest or truthful witness at paragraph 156, page 96. I said 94, I was wrong.
What?
But she then relies only on his evidence to bring forward in time the licking of the penis, very serious allegation. As my Lady Justice Macur has said, beyond doubt a sexual abuse allegation, that one. Our point simply is that that actually arose in 2022 alongside the retractions. And so the struggle for my client...
And where does the judge say something different? I think she did, I agree.
156 and then 162.
Hang on one second.
The last 4 lines of 162 on page 98.
But 156 is all about his dishonesty in the the pornographic video on his phone.
Yes.
Which showed a 10-year-old child, he said, being taken from the street and raped in the back of a car. So that's all about 156 and why the judge finds him to be dishonest about saying he misunderstood and Miss L misunderstood him. And you say 162?
Bottom of 162, I believe the stepfather's evidence that he had a similar discussion with the mother shortly after 2017-18 Hatfield discussion. The short point is the judge is cherry-picking the father's evidence, having said, I don't believe him. But she's believing him when it's against...
Yes, I see.
But finders of fact do that all the time. That's what they're there to do. They assess the whole of the evidence. Just because you don't accept part of somebody's evidence doesn't mean that everything they're saying is a lie. Especially if it's contrary to their interests.
Finders of fact have to explain why.
That's a different point. That's a different point. That's a reasons point.
And I'm grateful to my lord. I'm coming on to that point. This judge has not explained why we've cherry-picked that. Nowhere in the judgment. And that is, I'm grateful to know the point.
You're trying to be succinct, which is very helpful. I think you're going a bit too fast for me.
Sorry.
The finding I had in mind is at 219, page 111. These are the findings. I'm satisfied that the mother failed to protect. In 2018,
Yes.
she knew they were saying the stepfather that by showing her appropriate videos, showing her pedals. So that is the finding, that she knew that was the allegation in 2018.
It is the finding.
Now, where does she get to that finding? You're saying, is that from 162?
No.
Where
Can I
does
take my lord through it? Because I was going to take my lord through it.
Oh, I see, right. Okay.
So, if we go back to the account given by the mother to the police in her interview, the account that we've already looked at, and that is in the mother's police interview in the core bundle at 154, 155, 156. We'll look at it if we need to, but it's 154 to 156. It's the account that my Lady Justice Macur referred Miss Howe to at the start of her submissions. And that is the mother describing what she knew earlier, this being the only source of this information, the local authority not having this information. I pray and aid on behalf of my client's credibility in passing. That does not include the more serious allegations at paragraph 219, those more serious allegations being showing penis, asking to lick penis.
Yeah.
So what the judge has done is bring forward those much more serious allegations into 2018 at paragraph, my lord is correct, at paragraph 219.
Yes, but I wanted to know what route, if it's apparent from her judgment, on what basis she has done that.
My point is that it is not.
Yes, I see.
She just cherry picks.
Well,
she does not.
Cherry pick is the wrong word.
No, it's
You made it up.
No, my lord, no. Because there is a passage in the judgment in which the father says this in his oral evidence.
Oh, I see. Well, that's,
and then
that's the passage I wanted to be taken to.
Yes.
I didn't know, I wasn't sure whether that was what 162 was.
163 and 166. Forgive me, let me just get there. The father says in his oral evidence at 163 that I'm paraphrasing now, my lord, I hope, for the sake of brevity, and I hope it's not unhelpful.
No, don't, I just want to read this, it's quite an important point.
163.
Yes, I see. Well, that's the answer.
And then 166 as well, my lord, please. The next morning, the father resumed his evidence by saying that he was giving the whole scenario between 2018 to 22. And in my parenthesis,
yes,
was resiling from that evidence. So that was before the court.
I've now got it. Thank you. It wasn't clear to me, but it is now.
So a difficult situation and a difficult decision for a trial judge to make, a fact finder to make, but it's incumbent on the fact finder to explain why. When the fact finder at paragraph 156 has said, that is a witness I do not believe, why that particular aspect of his evidence is believed, in the context of my client who is not held to be dishonest, in the context of my client saying something different in her police interview, and the child not having said this on any primary evidence at that time. The only source of this information for this date, for these serious allegations, the only source was his oral evidence to the court, which he then says is mistaken. On behalf of my client, I would respectfully suggest I don't need to worry about what the father says, because he's already been held by the court to be not believable. He could also be mistaken here. And bringing it back to the judgment, the rationale for this is absent. And this is very, very important, because this obviously puts those very serious allegations at a time very distant to the retractions that start in 2022.
I think, well, I appreciate that this is a particularly important and unpleasant allegation. But the mother was very clear that she was very upset when she first heard the allegations, boiling, all the rest of it, drove off to Hatfield to confront him. I agree, she doesn't say it was because of this. Presumably it's because of inappropriate touching and watching pornographic videos with her. That's effectively the bits that she had been told about.
So the allegations
Isn't
that
that what the judge is? Isn't that sufficient to support the judge's finding?
where is the judge asked in making these findings of fact? The answer is nowhere. But I ask, where has the judge asked whether the anger of my client is forensically probative of what the allegation was? It might not be. It might be an emotional response. It's an appropriate response to such allegations, and I'm not trying to talk my client away from that appropriateness. But it's not. It doesn't shed a great deal of light on what has the child said.
You may have misunderstood me.
Sorry.
I wasn't suggesting that you could learn from the anger that there had actually been an allegation of, let's go into Latin, of fellatio, if I say it correctly. But what I'm more saying is the allegation of failure to protect would be sufficiently made out by the remaining elements that she had been told about, which she clearly was very upset and distressed about, and then didn't go to the police about.
Respectfully, no.
Yes, I see. You think that's a crucial element?
This judgment suggests that failure to protect is made out because professionals weren't called. That is a very limited understanding and analysis of what is failure to protect. This mother spoke to members of the family. This mother acted, and can I repeat, and I'm sorry if it is a repetition, acted on some sibling touching, an allegation of kissing, and an allegation of one pat of a clothed bottom while in bed.
What about showing inappropriate videos?
My lord, that does not appear in my client's ABE interview. That comes later. Now, the global point here, and I hope I'm getting to, forgive me.
There you are.
The global point I'm making here is that the struggle that any mother, any non-perpetrating parent would have, like the professionals on the ground, in balancing the cogent retractions with the primary allegations, can only, on my case, kick in 2022 when the retractions are beginning to be recorded and cogently. So I accept that there wasn't that struggle in 2017-18 when the retractions are less cogent and less obvious. So it's very, very significant to the...
There's no evidence of any retractions in 2018.
No.
What there is evidence of is A saying, my mum said she would take care of me, and I'm paraphrasing now.
Respectfully agree.
And so, so mum didn't have to consider retractions at that stage.
She did not.
And your point is that the judge accepted the mother's evidence? Because I think that the judge didn't.
My point is that the judge has worked hard in this judgment to bring forward the very serious allegations.
2022 allegations to 2018.
To get them away from the retractions. I'm sorry, I don't mean to imply cynicism in this, Judge. No, I really don't. But the judgment works hard at that. When it's all it's got is the stepfather, he says mistakenly, in the witness box, giving a date. That's the only evidence of that date being valid for those very serious allegations. And by the time they actually appear, and my lords, my lady has the chronology of allegations from Miss Findus that is so helpful to anyone coming to the case like myself and like my lords, my lady, that chronology makes clear that the retractions start in 2022. And that struggle for understanding a non-perpetrating mother struggling to understand in the community, that submission is only open to me from the moment that those retractions appear. Yeah. And that's why it's so important. And I do submit unfair on this mother to cherry pick the father's evidence in order to bring that in order to achieve a failure to protect.
Take me a bit of time to get that, and I see exactly what you're saying.
And so we do say that failure to protect finding cannot stand. On law on failure to protect, the reason that we haven't put in any law on failure to protect is that we respectfully agree with the judge's very short summary at paragraph 30. Failure to protect cannot be a bolt-on. She summarises Lady Justice King in the well-known case on failure to protect, and we don't criticise the judge's approach, recitation of the legal principles in relation to failure to protect. We do say, I've made the point about the date, we do say those earlier allegations were not so serious. They were certainly not nothing, but my client acted within the family as opposed to calling a professional. And the judge seems to, throughout this judgment, be saying that it's failure to protect if you don't pick up the phone to a professional. There wasn't a social worker allocated in 2017, so presumably it's to the police. And I respectfully suggest that failure to protect is a very different beast to just calling a professional. There can be actions in the community. In 2022 and onwards with the more serious allegations, I do accept those are more serious, but my client is struggling with the retractions. I'm sorry, I'm repeating myself. I'll stop.
Before you go further, can we just stick with 2017 to 19, whenever in that period?
I'm going to try.
No, just for the purpose of the question.
Yes.
Mother was very, very concerned, very angry, to the extent that she drops the 4 children off at her mum's home and drives to the stepfather's work. In itself, an indication of something out of all norm.
Agreed.
Because, of course, she, in other words, if it was just, I've seen A kissing B and she was pinching his bottom or something like that, can wait for stepfather to come home.
Yes.
Or father to come home. She goes there and she confronts stepfather according to his own evidence.
Yes.
And according to mum's evidence.
Yes.
So she was acting appropriately, you would say.
Totally.
But the judge then finds that having spoken to the stepfather, and he denies it, she then goes back, picks up 3 of the 4 children, leaves A with grandmother, and A is left with grandmother for 3 or 4 days.
Yes.
And then A's brought back into the family home.
Yes.
Because mum can keep her safe.
Forgive me, my lady. Mind if I turn my back?
Of course, yes.
Yes. I'm very grateful to my learned junior, who was trial counsel, for reminding me that on the way to that meeting, it's when the phone call arrives from the grandmother saying that A is saying, I've told lies. Is that the Hatfield incident? The Hatfield incident, as it's referred to. So already my client is then facing A, reporting via the grandmother that, if the grandmother's telling the truth, and the denials of the stepfather, and allegations that, despite my client's appropriate response, that response not shedding light on truth or otherwise of the allegations, or in fact what the allegations were, and they're being, and I hope I'm not making a submission that that they were capable of being ignored because my client didn't, or they were not serious, because any allegation is, but they were not in the category of the very serious allegation that comes later. That may not be a point that helps me a great deal, but is a fact on this case. And I say that what this judge has done at paragraph 219, that my Lord Justice Underhill has helpfully referred me to, is she's just elided them all into 2018 in order to allowing the door open to failure to protect without a proper analysis of severity, the responses. And I'm very grateful to the summary of what happened, and I respectfully agree it with that addition from behind me.
Why leave A behind at Granny's? If Mum didn't think that something had happened, why leave A behind at Granny's for 4 days?
Well, my lady, perhaps, my lady,
because the judge comments on that. So,
yes.
So the judge is standing back saying, well, this is what I've heard. I mean, accepting the indication that grandmother had called halfway on the way to Hatfield, Mum still carried on, still had the confrontation.
My lady, is it not open to a layperson struggling with different sources of information, as the professionals have struggled, trying to be protective and appropriate, to let the dust settle and to look at and try and analyse what those sources of information are?
But what I'm trying to say is that the judgment may not say explicitly, well, I draw together the evidence of the stepfather who I disbelieve. However, I take into account the mother's own accepted behaviour, what the mother said she saw had occurred between A and her brother, and the fact that A was left with her grandmother, because the judge makes quite a thing about that.
Yes. But, my lady, as this information unfolds within a family and to a lay person trying to do her best, it doesn't, in my respectful submission, it should not mean that something is preserved in stone. That if A is there for 4 days while the mother is trying to work out what is going on, it doesn't mean that it can't change. The mother, in my respectful submission, has acted in an appropriate way. The fact that that regime then changes in the context of what the allegations then were is, in my respectful submission, not a failure to protect, because the mother has acted and has acted appropriately. Yeah. I can see that there's a first blush, a prima facie criticism of her for not sticking to it, but it's not the allegation of licking of a penis and clear sexual abuse. And it's then very quickly muddied waters, a muddied picture from A herself via the granny. And
well, on that last point, I've just been looking at I must say I hadn't understood this when I read it, but maybe you're right. Page 84, end of page 116, the mother said that the grandmother then called her. I'll give you a moment to find it. Page 84.
Thank you.
You there?
Yes, thank you.
End of page 116. The mother then said the grandmother then called her. That I'll assume you're right. That means on the way to Hatfield, and said A said that that must be that the mother had threatened her, and that it was not true. Is that saying that the allegations weren't true, or that the allegation of threat was not true? I mean, it's a lot to pin on something which.
I have read that as the threat wasn't true.
Okay.
But my lord's asking me to.
Well, no, I thought you were saying that effectively A had made a retraction of the allegations to the grandmother, which the grandmother then reported. If that wasn't what you're saying, I haven't got a problem. That's the first I'd heard of such a retraction.
It's the Hatfield. It's known by those at the trial as the Hatfield incident, the call from the grandmother on the way to Hatfield, and it's the start of the muddying of the waters, which I say, although much less clear. I'm not resiling from what I've submitted earlier. Much less clear than 2022 onwards, where the retractions really do become much more cogent and much more recorded via the ABE interview.
You explained it to me. Yep. Right, where now?
My lord, I think that I have finished ground 4, failure to protect, and can I just bring in ground 2, the reversal of the burden of proof? And it's back to, I hope it bears a little repetition, it's back to the starting generalised point, which is that this is an assessment of witnesses, and A was a witness who didn't attend court for oral evidence, but was willing to attend court to explain to the judge that she had lied. No one required that. The judge didn't require it. But what the judge then does not do, and I'm afraid this is an absence point, so I'm not sure I'm going to be able to give any page references for the judgment. What the judge does not do is balance A as a witness. The judgment reads in my submission as, here are the problems, I recognise the problems, but the questions to the mother in the witness box, the general approach of the judgment reads as, is A believed? An example of that, my lord, is the debate about the shaving of the head. This is not something I am seeking to resolve from. My client has always expressed shame for shaving of the head, has accepted that the threshold criteria is met for no other reason than her response to the shaving of the head in late 2022. But by that stage, my client has lived through the retractions, is openly saying to professionals when she hears of another allegation, oh no, not again, lives are being ruined, all of which in my respectful submission is within the gift of a quote-unquote Section 31 reasonable parent, because she's lived through her child explaining to her that she has lied, and she's struggling with that. And the judge goes throughout this judgment without differentiating, and if I may say so, Mr. Lamb will forgive me, the local authority do it in their skeleton too for this court. The judge and the local authority go through the issue of shaving the head for lying on the assumption that it's lying about making proper allegations. as opposed to contradicting yourself and lying because you say someone sexually abused me and then that's a lie. And that's the sort of issue that my client was facing on the ground, and the judge does not properly engage with in the failure to protect. And in my respectful submission, this failure to protect finding is a reversal of the burden of proof, and is also, it falls into the category of a bolt-on finding to the primary points in the case. I know that my time is up.
No, you've been very succinct.
Can I
and clear.
assist further?
No, not as far as I'm concerned.
I am a bit troubled about your reversal of the burden.
Yes.
Because I didn't quite understand. I can understand you saying the judge did not give an appraisal of A's truthfulness sufficiently able to explain that a truthful child is obviously lying, whether in making the allegations or making the retractions.
Yes.
But why does that reverse the burden of proof?
Because
I think what you're actually saying is that the judge didn't understand that this mother was in a quandary of emotions, and she's assumed the worse against the mother because the mother was found to be an unreliable witness.
I'm certainly saying she's assumed the worst of the mother. It reverses the burden of proof because fundamentally, and stepping back, this is a case in which there is no ability to analyse the primary allegations. This applies to my client as well. It's why it's relevant to my case on failure to protect. There's no ability to analyse the primary allegations because there is no ABE interview of them. There is an ABE interview that, in my respectful submission, it's a short submission, is cogent, is reasoned, has an emotional resonance for the child, with the child giving reasons for why she's lied. We've listed them in our skeleton argument. And so the judge comes to the juxtaposition on a retraction case with only the retraction and without the child who is a witness saying, ever, it's true. And so the judge has reversed the burden of proof in making the assumption that there is a truth, undefined, unrecorded, and that's the thrust of the judgment and the thrust of the approach in the
Well, I
argument.
think, we have the point. That's how you put it.
I'm grateful.
Yes. Thank you very
Thank you.
much indeed.
Yes, thank you.
Monsieur.
Thank you, my lord. I won't trouble the court with long submissions, but I would like to say something about the retractions.
Yes.
I'd like to focus on 3 retractions, the most important ones that we are looking at. There are 3 retractions: 18th of January 22, 30th of November 22, 5th of December 22. The first one, 18th of January 22, police officer in the ABE. The judge deals that in her judgment at paragraph 75. The police officer gives evidence to the judge, and his view was that A kept a coherent account and provided a clear narrative. Judge also deals with that in terms of that very lengthy ABE where child A is put through all sorts of questions. Judge deals with that at paragraph 192 and 198. What the judge does not do in those paragraphs is say why, despite the fact that she considered the evidence of the police officer, she accepts the evidence of him, and that's stated at 192 and 198. She doesn't say why, that despite the fact that that police officer considered there was no pressure put on A, or that and that it was reliable, why she doesn't balance that out with other evidence. That is not done. That interview, that ABE interview, is not scrutinised by the judge. I would say that scant regard is given to it in paragraphs 192 and 198. It isn't gone to in any detail. The judge, as a cover-all, says all of the retractions have to be seen in context. But what the judge doesn't do is take into account this was first-hand given by a police officer who saw the child on the previous day, and was satisfied with her account. That is not dealt with in the judgment at all. Second retraction, which is at the 30th of November 22, TC, social worker. Again, the judge deals with that in paragraphs 93, 94 and 95 of the judgment, 95 in particular. The witness, Miss C, in that case, explained that there was a coherent narrative given. The judge accepts Miss C as a truthful witness, but she does not say in her conclusions if that was the case, and TC was of the view that this child had not been pressured in any way, and they accepted the retraction which she was sent to the school to do. She says that, and the judge deals with that in her judgment. Also had met the child on 2 occasions, just like the previous police officer, does not deal with a very real issue, that professional witness was satisfied with the narrative that was provided by the child. She doesn't say why she considers that witness was wrong to be satisfied, and doesn't say in any way or go through why that narrative was unreliable and why that professional witness got it wrong. Thirdly, 5th of December, which is another retraction to the police officer, different police officer, paragraph 84 in the judgment, and in his oral evidence to the court, he said there was no reason to believe that she was not telling the truth on the 5th of December. That was, and that is dealt with in the judgment, paragraph 84. Again, agreed there was a plausible explanation given by child A, and again the judge says at paragraph 88 that that particular witness was a honest witness. So 3 professional witnesses who have all spoken to child A, unlike the judge, came to these particular conclusions with respect to their meeting her. And I would submit that and I've given the page references, that was not dealt with adequately and child A's voice was not heard.
Thank you. Very succinct and on the point. Thank you.
Thank you.
My Lord, I'm making submissions on behalf of the Respondent Local Authority. Could I just begin by drawing back the court's focus from the detail to what this judgment strove to achieve? Perhaps before I get there, could I just reiterate all the authorities most succinctly summarised in Volpe and the references at page 165 of the authorities bundle. Of course, the appellate jurisdiction, particularly in my submission in respect of fact-finding challenges, can only be triggered if the judgment was plainly wrong and that no...
we're not allowed to say plainly anymore.
I'm so sorry?
We're not allowed to say plainly anymore.
No, quite.
We've got to say it was wrong.
Yes, but nevertheless, that no reasonable judge would have reached the conclusion. And my Lord...
Well, let's not argue about the exact formulations. We all know that it's an uphill task to overturn findings of fact for a number of very good reasons given to the authorities. That's really all it comes to, isn't it?
Yes. And the judge, in my respectful submission, was well aware of the task she was facing. And she sets out, right at the beginning of her judgment, in fact, all of the issues that have become apparent on this appeal at paragraph 17 of that judgment. So the overall impression of this judgment and the starting point of the judgment, my Lord, is that she knew the deficiencies in evidence and she knew the task that she was faced with. My Lord, it was interesting to note that my learned friend, on behalf of the appellant's submissions, did not begin with the allegations, the more historic allegations, because in my submission, they're very important and they're very unhelpful for the development of the case. As we were reminded in an authority presented by the appellant in Re S, if one is looking at the cogency of a series of allegations, the evolution of those complaints must be considered. And my lord and my lady, the evolution of the complaints that this child makes is very important. We say there is safe evidence upon which this judge founded her conclusion as to much more serious allegations being made in the 2017 to 19 period. It's already been addressed, my lord, as to the mother's evidence on her demeanour at that time. It is not consistent in our respectful submission that these allegations at that point were of the low level suggested to you in submissions. And the judge was right in our submission to look at the credibility and the evidence of the stepfather within this context. But before we get to that point, in looking at what the parents were saying, the mother and the stepfather were saying about what was happening at that time, is very important. There are a couple of vignettes within the evidence, my lord, that I'll draw your attention to. First was what actually were the accounts of the child placing her hands into the brother's underpants. The judge picked up on this at paragraph 146 of her judgment, and there were differing accounts as to how this information came about. The mother said that she was told by the stepfather, and the stepfather said that he had known nothing about this, and that she didn't say anything about it. So, my lord, immediately when this judge was tasked with unpicking what was happening on the ground in 2017 to 19, what was the judge to do but to look at the respective credibility of both of these parents? Another inconsistency comes with their recollection of what life was like at home. Paragraph 147 of the judgment. This was the mother's comment that pretty much immediately after these allegations were made, the stepfather was avoidant and spent very little time with the child. One compares that with the stepfather's evidence that he said everything was normal. It settled back and A was always okay with me. My lord, my lady, there is discrepancy in the reporting of what was happening within the home.
Can I help you with this, I wonder, because you've skipped over it rather. In paragraph 146, when we're talking about the evolution of these allegations, the mother described being very angry at what A had done to B and said she thought A might have learnt it from her father. I did not find mother or stepfather's evidence about what they'd seen A do to her siblings persuasive or credible. So on that basis, what did she find had happened? Nothing? In which case this feeds into Mr. Toogan's point that there was no failure to protect in 2018. The judge just leaves it. If neither mother or stepfather were honest about this, what did the judge find?
Milady, first of all, the judge had the comments made in the mother's police interview about what she understood to have been happening. And second, we then turn to the interrogation of the issue in relation to the stepfather's phone and what the pop-ups on those phones were. It was clear that either the stepfather was being entirely dishonest about the sort of things that were cropping up on his phone. Coincidentally, at a time when it was being reported that the child had seen adult behaviour on that phone and then repeated it.
I'm sorry, it's not the point I'm asking, it's obviously me being very clumsy. In paragraph 146, the judge discusses the evidence that seems to have been the basis of the finding that mother knew what was going on in 2018. Because there's evidence that the mother was told by the father, that is the stepfather, that A had been acting inappropriately towards B, her brother. And that included kissing him, putting her hands down his pants. In paragraph 146, the judge deals with this and says she doesn't believe the mother or the stepfather. So I'm just wondering what's left if you just completely erase their evidence on the point.
My lady, the next part of the judgment
In
from
147?
a little below that actually, from 157 onwards, and this is the section where counsel for the local authority was at pains to take the stepfather through the evidence, and in particular at 159. At the bottom of that paragraph, 159, the stepfather clearly told the court that a few days after the Hatfield discussion, the mother told him that A had alleged that he had shown her pornography and kissed her. When he was asked how...
Sorry, where are we reading
I'm
from?
sorry, at the bottom of paragraph 159.
Sorry, the line with a few days underlined.
Yeah.
Yep, okay, got it.
The mother told him that A had alleged that he had shown her pornography and kissed her. And when he was asked how soon after that he was asked by the mother about showing his penis to A, the stepfather said it was a few days after. And then, lady, we have the deconstruction by the judge of why the stepfather's evidence was simply not believable, because the stepfather was taken through very carefully by counsel for the local authority in the terms just over the page, again in that same paragraph, taken through the chronology, and his clear evidence, as the judgment says, was that within a few days of the Hatfield discussion, he was told by the mother that A had alleged that he had shown her how to kiss, shown her pornography, and on top of that, I showed her my penis. He could not have been clearer about what he was told and when he was told it. I believed his evidence on this. Having considered all the evidence, I'm in no doubt that the mother knew more about A's allegations than she admitted to before they came to professionals' attention in 2022. So we say that, of course, in the absence of contemporaneous reporting from this time, for the obvious reasons that it was never reported to a professional, the judge appropriately and skillfully in our submission drew out, on the balance of probability, what was in the parties' contemplation at that stage. And of course, the background evidence makes it all the more compelling to use as an example the evidence from Miss L, who was part of the family assessment team, and the rather unpleasant evidence about the video of the rape, and then the stepfather's flat denial of that in his own evidence. So, my lady, we say the judge did everything she could and appropriately to define what the allegations were at that point, and in so doing considered the various inconsistencies and inherent improbability of what the stepfather and or the mother was saying at this point. Much has been made, my lord and my lady, as to the lack of contemporaneous reporting in this case. There are two short points I wish to make. Criticism was made of the detective constable in this case, that he couldn't remember the allegations or the conversations relating to the allegations in January of 2022. That was not the evidence that was before the court. The evidence before the court was compelling in our submission in respect of his note-taking abilities. Paragraph 71 of the judgment which is core bundle, page 72. And in fact, the record is at page 70. The detective constable told the judge that he typed up the report almost immediately. There's reference in that paragraph to the Chris report, the police report being dated the 18th of June 2022. I think that's a typo in the judgment because the police report clearly says it was from January. So there was an immediate and a contemporaneous account recorded at that point.
So where's the wrong date?
At paragraph 71 of the judgment, my lord. It's about halfway down. His recollection was that he did that on the 18th of June, so did that refers to typing up the note, or actually...
that's the wrong date, that
yes,
should be January.
Yes, and
okay,
it's shown in the...
Yeah, that's fine, that's all I wanted to know.
Police report. My lord, so it's not right that that set of allegations were not contemporaneously or accurately recorded. Because if we then thread through to the next...
Sorry, just before you leave that point, I think one of the criticisms that's been made is that there's just a summary, that there isn't a record of what questions precisely were asked and what the answers were. And it said that's contrary to good practice.
Well, my lord, they're clearly not there to be seen. And the judge was live to the deficits in the reporting. In many instances, the judge refers to the fact, particularly with DL's evidence, that there are no questions being recorded, and that is regrettable. But again, the judge is doing the best she can with the evidence that she had. And we would say she was entitled to conclude that the evidence from the detective constable was valid, and she commented on the basis that he was ABE trained, and albeit this note didn't reflect the guidance, that she could be satisfied that it was an appropriate discussion between him and the child.
You can have appropriate discussions but still come away with the wrong impression because there is no contemporaneous, detailed record of questions asked and actual answers given. Because one of the problems when people summarise and they don't leave a trail, as did TC, using words that were beyond a child's comprehension, is that you can get the perception of what's being said rather than what is actually being said. And I think one of the points, certainly I'd like you to address whilst you're on the point of DCL, is Ms. Tooney's point, which is if DCL is assessed by the judge to be a professional who is up to date with his training, who knows exactly what to ask and how to approach such a sensitive topic with a young girl, why is it that his view on her retraction immediately the next day, he being involved both the receiving of the allegation and also the retraction, that isn't dealt with or weighed appropriately? What do you say about that?
Milady, the first point, and it's obviously a point that's been made by this appellant repeatedly, is that the judge failed to give weight to the professional's views of the retraction. It was for the judge to determine, with the totality of the evidence as she saw it, whether or not a retraction was sustainable within the context of the case. One has to accept, of course, that the retraction, the ABE retraction that followed the next day, was a sufficiently cogent retraction interview. Seen within the context of the development of these allegations, seen within the context of the judge's, we would say, better knowledge of all the other factors that were at play in this child's life. The judge's views on her relationship with her mother, the judge having heard evidence in particular from the maternal aunt, who gave evidence, which is at paragraph 100, that this was a child who cared deeply about how people felt and felt a big impact following the arrest of her mother. Those are the sorts of human elements to the judge's inquiry that we would say is entirely appropriate for her to have reached that conclusion.
I understand all of that, but I just think that perhaps if we can get the answer, we should from you. The judge, of course, has got to make a decision on all of the evidence, and all of the other people who heard the retractions don't necessarily have it, don't have the responsibility to analyse it, as did the judge. But it's the complaint that's made is that the judge doesn't say, well, I give credence to what's been said, particularly by DCL, because I have paid very, very close attention to what he said about the allegations. The reason I do not accept the very potent evidence, as some would say, of A, actually being seen to retract, not being reported to retract, but being seen to retract, is A, B, and C. I think the criticism is she rather skips over it all because she's so anxious to preserve DCL's credibility concerning the allegations that she can't quite do the same as she's done with the mother and father in saying, well, I believe him on this bit, but don't accept his evidence on that bit.
Milady, the DC's subjective view of whether the retractions are compelling and whether those retractions were, for example, freely made is in our submission an entirely different point from the judge's wider view of the evidence as a whole. And we would say that it was not incumbent on this judge to specifically address the point that you're putting to me, my lady. Because if one stands back again and reads her judgment as a whole, her analysis of how the child's presentation to other family members, to her school teachers, how that all fits together, we would say gives a sufficient basis for the judge to discount the only ABE of this child in this case in terms of the truth of her retractions at that point.
Would you say we should imply that, even if it's not expressly to be found?
Yes.
But do you see that this gives credence, or could give credence, to the complaint, that this is an unbalanced exercise, that the judge goes to great lengths in saying, I believe father when he says this about mother, but I don't believe a word of what he says otherwise. I believe what mother said, which is against father, but not when she tries to distance herself or distance him from some of the allegations.
My lady, the overall impression is one of balance in this judgment, we would say. The judge, for example, on one occasion says, I did believe mother at times, but this was not one of them, and that was in relation to the lock of the door. These were, I suppose that's a good example of, on the narrow basis of the point we are discussing, balance may be absent. But the way, for example, the judge sets out the difficulty of her judicial task at the beginning can reassure this court that she was balanced and was fair. Because, milady, we also then turn to how the judge deals with the head shaving. This was obviously, as accepted on behalf of the mother, an awful thing to have occurred. And the judge was at pains to look at what the mother's account was and consider whether or not that was an appropriately plausible explanation. And she does that in some detail in her judgment. Similarly, again, standing back, that there is balance, and one has to accept that there will be areas where the judge may have been more explicit in reaching her conclusions. But overall, and taking this judgment as a whole, it's entirely sustainable on all of those points.
Just on the retraction in January point, I've been looking at page 104, paragraph 192 of the judgment. Does that cast some light on what the judge's reasoning may have been on this question?
Well, yes, this paragraph, again, lends credence to the idea that, that this judge has considered how this child is presenting within the wider context of her own case. And at this paragraph, the judge is clearly weighing up how she deemed that ADE to be sustainable, my lord. Could I just turn my back for a second? Just a final point to make in respect of the detective constable. He was not aware of the historic allegations that had been made by this child at the point of the retraction. So again, that's just another point that goes to my submission on context being very important.
Well, it was the same DCL who'd gone the day before, hadn't he? And met with DL, the teacher.
Yes.
And been told what DL had been told, which was about the historic allegations. So of course he knew about the historic allegations.
Yeah, I understood you to mean something different, that he wasn't aware that allegations had been made before in
Yes.
2016 and 2018,
Yes.
which he wasn't,
Yeah.
but I don't quite know where that gets you.
Yes. Yes.
That is what you were saying,
Yes.
but why is that helpful?
My lord, because he didn't have the context that this was a child who had made allegations
Oh, I see.
from that period of time. November 18. My lord, those are my submissions, my lady.
There was criticism made of, I think it's the witness CL, that she was permitted apparently to give oral evidence about matters which had not been foreshadowed, either in contemporaneous notes or even in her witness statement. Do you have any submission to respond to that allegation?
My lord, could you repeat the point, please?
Yes. I may have misunderstood, but I think one of Miss Howe's criticisms of the judge this morning was the way in which she dealt or failed to deal with the evidence of, I think it's the witness CL. And the particular submission that we heard was that CL gave oral evidence at the trial on matters which had not been foreshadowed, either in contemporaneous notes or even in her witness statement for the hearing. Now, if that's right, and if the judge simply failed to deal with any of that, on the face of it, that might be thought to have some force as a criticism of the judgment. Because we have to put this in context, as my lord has been at pains to stress several times during this hearing. We're not the court of first instance. What we are interested in knowing is whether there are any valid criticisms that can actually be made of the judge's approach and whether the conclusions were open to her, reasonably open to her on the evidence before her. Because if no criticism can be made of her approach and her conclusions of fact were reasonably open to her on the evidence, then that is usually the end of an appeal. So I think what's being said is that there are valid criticisms that can be made of the judge's approach to the evidence. In other words, it's not simply complaining about a finding of fact. And that's the specific one that I would invite your response to, if there is one.
But my lord, the evidence of CL, particularly in respect of issues that did not appear in any of the documentary evidence, is dealt with by the judge, for example, at paragraph 59 of that judgment.
59.
59. And we say that is the judge recording that evidence and then analysing it in the subsequent paragraphs in an entirely appropriate way.
Incidentally, when he says CL told the court that A alleged, is that a shorthand for that A alleged to her peer who told me?
My lord, I'm sorry, where's that reference, please?
Para 59 starts, CL told the court that A alleged. Am I confusing myself? I thought that CL had not in fact spoken to A at all. I could just be confusing myself.
Yes, my lord, she did speak to.
Oh, I see. But remind me when. Did anyone do that business of marking up the?
My lord, it's a work in progress.
She did. Oh, I see. Right. Okay. Well, I've obviously got that wrong because the sequence of events in that week are the ones that I find most difficult to follow.
I do think my lord has got it wrong. The record that we were taken to at 6:02, was it?
608, I think.
608 was confirmed to be that it was blank who spoke to the teacher. And Miss Howe's point was that it's quite clear that CL was having further conversations with A that were not recorded on any documentation. So my lord is quite right that this particular paragraph appears to be referring to something that is not, as my lord or Justice Singh said, foreshadowed in the witness statements or in the documentation.
So this must be a reference to her evidence in... How did it go with CL? I'm afraid you'll have to take instructions, if that's the right word, from your junior on this point, because he was there. Did CL give further evidence in chief? You wouldn't normally do that if there was a witness statement, but maybe you would if counsel was aware she had more to say. Or did all the things that were in the oral evidence come out in cross-examination or re-examination? Anyone who's there can answer, as long as they're sure of their answer.
My lord, Miss Flinders is just checking her note.
Just as a footnote to my lord's question, can I make the point that pages 70 and 71 of Core Bundle 1, paragraphs 59 through to 69 of the judgment, the judge appears to be recording a lot of evidence. So just by way of example, paragraph 68, towards the end of her evidence, CL said that she did not think that A was trying to seek attention from the adults around her. So in some way, whether through evidence in chief or through cross-examination, the witness does seem to have said a lot at the trial, which is being, I assume, accurately recorded in this part of the judgment. And there may be nothing wrong with that, but I think the complaint is made that this was not evidence that was foreshadowed, and you certainly don't have contemporaneous documents, as far as I can tell. See page 608, for example, which support this account. Now that may not matter, you may say, but I think we do just need to know precisely what the nature of this witness's evidence was.
Her witness statement is, in fact, rather longer than I recall. I looked at it a couple of days ago. It's yesterday, seems a long time ago, 434, behind tab 23 for those of us who have tabs. There is quite a lot of, I haven't checked whether all the things that the judge records are in this witness statement. But it's not clear either
My lord,
to what extent this is simply reproducing what you can find in the paperwork. I'm pretty sure it isn't, so we haven't seen any of it. Or was her presumably giving evidence from her recollection? Someone was about to speak.
my
Sorry.
lord, there are 3 witness statements from CL.
Right, where are the other 2?
There are 2 at the supplemental bundle at 176. Is the 13th of March and the 22nd of May. So it is at 178.
Wait.
There's one in the
Supplemental bundle.
supplemental. I'm right at the end.
Okay, give me a second.
176.
No, I'm being slow.
I do hope I put the right yes.
Okay, supplemental bundle. So that would be tab or document I see both of them at the end. Yes, those, that's right. Well, we were shown one of those this morning. Well, it's useful to have those, yes, but is anyone, as I say, anyone from volunteers, anyone who was there, it wasn't all that long ago, able to tell us, was the position that the bond simply went into the witness box and verified the truth of her 3 witness statements and was then cross-examined, or was she asked further questions in chief? You can tell us direct, Ms. Vindis. It's probably less chance of Chinese
I'm so grateful, my lord. So I've had a look at the note of the evidence, and because I was on my feet and therefore not able to take a note myself,
yes,
Miss Roberts took a note of, so it's actually her note that I'm working from. But I can confirm to the court, having checked the note, and I just want to bring it up so I have it in front of me, that my chief started at 11:42 with the witness on that particular day, and the note that I've got of it concluding. It looks as if the cross-examination of the father, which was the next person to ask questions, was at 12:35.
I see. So she gave further evidence in chief.
She did.
For about 3/4 of an hour.
Yes. And in terms of the sort of broad areas that were covered in chief from the 3 statements, there's additionally an account that the court has heard about that Miss L gave to Dr. P. Within the assessment that he undertook of the father in December of 23, forgive me, so just before we started our hearing in January. And some of the information that was given by Miss Le Bon was also recorded in that conversation.
Yes, I see.
But in essence, the gist of the questions that I was asking.
Well, it's not, I mean, my lord, my lady may want to ask you a particular question. I was trying to get this structure in my head. The answer is she gave quite a lot of evidence in chief, in addition to anything that was in her witness statements and in the account, the second-hand account we got from Dr. P.
And the purpose.
And then cross-examined, certainly by the stepfather's counsel and probably by others as well.
Yes.
Okay.
So I've got, in terms of the, when I can find the times.
Well, at the moment, I won't ask you for times because it's not that. We're just trying to get a picture. There's a lot of evidence. There's a lot of evidence attributed to Ms. Le Bon. I'm doing it now. CL in the judge's judgment, but it's not clear where it comes from. But the answer is, if we can't find it in any of the witness statements, it must come from things that either from the summary account that she gave to the doctor, or it must come from her evidence in chief cross-examination. That's all pretty obvious, but I just want to get clear in my mind. And very little of it, certainly in the witness statements, is referred to documents, partly as we see that there isn't much in the documents.
No, I mean, the statements aren't in the ideal form. I understand that the witnesses were provided with the primary evidence that they were the authors of before those statements were drafted by them, and that has certainly been the intention. But there isn't any cross-referencing, so it's not obvious from the face of the statements, of any 3 of those statements, exactly which document the witness is referring to when she
Yes, I mean, it's not apparent, for example. You wouldn't know from that whether they were, as it would be perfectly proper, but they ought to spell it out. Simply looking at documents and feeding back what they could get from their documents, or whether they had independent recollection.
And my lord, it was precisely for that reason that I thought it only appropriate in advancing the case on behalf of the local authority that I went through that exercise in chief with the witness.
Yes, I see.
And that was.
No, well, that does you credit because the witness statements aren't in a very useful form. But since we don't have a transcript, it only gets us so far. Right, well, I'm sorry, we explored that perhaps rather too much length, but it was really, well, do you want to ask any more about it? We just have to work it out.
Thank you.
Yes. Yes, Mr. Toomey.
Lords, my lady, may I just remind the court, not that the court needs any reminder from me at all, but of the phage advantages, as I've termed them in our skeleton, that this judge had.
Yes.
And indeed, if I may, at page 5 of our skeleton, just remind the court of the guidance, a particular guidance, paragraph 115 of Lord Justice Lewison's judgment, that there's no duty on a judge in giving his reasons to deal with every argument presented by counsel in support of this case. His function is to reach conclusions and give reasons to support his view, not to spell out every matter as if summing up to a jury. And the next page refers to Justice Lewison's judgment in Volpe. And can I just draw attention to Roman numerals 5 and 6 of paragraph 2. An appeal court can, therefore, decide a judgment on the basis that the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally unsupportable. And 6, reasons for the judgment will always be capable of having been better expressed. An appeal court should not subject a judgment to narrow textual analysis. I know the Lords and Lady have that point, but that is our starting position, that this judgment is sustainable in relation to all the findings made. This was a judgment that in our submission rightly relied upon the allegations from 2017 or 18. And if I may just briefly then go through certain points relating to each of the allegations chronologically and start with 2017. And the first point is that this issue was first raised by the mother in January of 2022. We have the note of the social worker's record of her conversation at 118, but it's a relatively brief summary of a child who was found to be kissing a sibling on the lips, and a child who alleged that she'd been taught that kissing by her stepfather, that she'd observed adult material on his phone, and that he had touched her bottom when she was sleeping in bed. The mother's evidence to the court is at paragraph 116 of the judgment, page 84, and it's a similar expression that what she says that when A and the stepfather were in the living room, he's alleged to have shown her a video of people kissing. One day when she was in bed, he came in and touched her bottom. She said that she understood A to say that A and the stepfather had kissed. And she was so upset that she rang her own mother. She was shaking. And she said that the allegations arose when she first challenged the child about the child herself kissing her sibling. So that was the evidence, the initial evidence before the court. And the mother said, in answer to that, that a number of things the judge did not agree with. So she said that A was becoming like a teenager. The judge dismissed that at 117 because the child was only 7. The judge dismissed that she was entitled to do the suggestion.
Are you giving page references or paragraph references?
I'm sorry, my lady. 117 is the paragraph reference.
My paragraph 117, yes. But the mother told the court that in around 2017. Yes, I've got it now,
Yeah.
thank you.
Give me. The judge did not accept her account of the child as a challenging child. The judge did not accept at 118 the mother was not angry with the stepfather on the evening of the 18th. The judge found that the mother was downplaying the anger that night. The judge at 120 finds that the mother did not want to believe A. And what we say is that the judge was entitled to reach those conclusions and was entitled to take those into account when considering the 2017 allegations. What is important, we submit, is that this was clearly sexual allegations being reported by A to her mother, and her mother understanding them to be sexual. And yet what the judge uncovers within the evidence is an attempt to step back from that when the mother is asked to consider it in more detail.
So when you say sexual, at this juncture, you're not including the penis
No.
allegation. So you're saying the other elements of what A was reporting to her mother in 2017
Yes.
was enough to constitute sexual allegations.
Yes, so what we say is that it was clear on the mother's own account that this is what she thought her child was telling her. And the judge says as much, and she justifies that, I think particularly in relation to sexualised behaviour. She sets that out very, very much in the judgment, but that is the mother's view, and we have the visceral response of the mother, the boiling, the shaking, the having it out immediately with the father. They couldn't wait until tea time. She went straight to have it out with the father.
And again, I think what you're saying is that the judge made those conclusions of fact, did not accept the mother's evidence about the putting hands down the boy's pants. Is that right?
That's right.
Yeah. But you say that doesn't matter because the two things might be said about that. Is first of all, that's the judge taking a balanced approach, which is that she doesn't just say everything happened. She assesses for herself what she's satisfied on a balance of probabilities did happen.
Yes.
Some bits of what's been said in this lengthy trial she doesn't accept.
Yes.
But other bits she does accept. And your submission, as I understand it, is that even without the more serious allegation that concerns the penis,
Yes.
that was enough to put her on notice that there was allegations of sexualised matters being made.
Yes, and if one only has to turn through the various tranches of evidence.
But just before we get, I just want to be clear about this. Not in those passages, but at a later passage, she does in fact accept that the complaint at the time included a complaint about the penis.
The judge does.
Yes.
Yeah,
sorry.
That's
we were
because she
cross-purposed.
puts different parts of evidence that she's heard at the trial together.
Yes.
Yeah.
But I think that you're taking it in stages.
Yes.
Because you're just focusing on 2017 for now. And what
Yes.
the mother would have known.
Well,
Even on those allegations.
the hands down the pants evidence is important because it was advanced by both parents as an explanation as to why this child, first of all, said the things she said at the time she said them, and secondly, by implication, if not expressly, that this was a child who had other reasons than sexual abuse by a stepfather for behaving in that way. So the dismissal, the finding of the judge that this explanation was not true, was important in the judge's final analysis. So it doesn't just fall away, it falls into the balance when considering the credibility of the mother and the stepfather in everything else they say. And it is perhaps most important, I submit, if one looks at the police interview. May I just ask the court to turn and look at those two pages, 144 and 145 in the Bible. Because this is the recorded account, 154 and 155. Forgive me. So this is the mother's account, recorded, so that we have no doubt about what she said, to the police. And it starts, as Neddy said, at line 22. And the first thing that's important at the bottom of 154 is that the mother is describing two incidents. So up until now, the evidence had been, and I can take the court to it, but we had various evidence of this being reported by the stepfather, but not seen by the mother, or this being seen by the mother, the stepfather knowing nothing about it. But what the mother tells the police is that stepfather says, you need to speak to your daughter about what she's doing to tea. So mother does that, and the response at that point is no, I haven't. And that's the end of it. But not no, I haven't, and then we get some allegations arising, but no, I haven't, that's the end of it. And then she says, and this is why it's so important, because then she says that she walks in on the two children. She said, I don't think she heard me. And then I found her myself, and I got angry immediately. So pausing there, she's angry because she's seen something that is outside of normal infant or younger child behaviour, normal kissing, normal cuddling, normal sibling behaviour. So she said, I approached her. She said she didn't think it was appropriate. They're both my kids, the boy's young and stuff. So
yes, sorry, just to be clear, the whole account really starts at line 10, doesn't it?
Yes.
And then that feeds into the passage
Yes.
you've just been taking. Yes, sorry, carry on.
I suppose my lord's quite right to say that, because what that does show is that the mother is putting this at the very early stages of her relationship with her
Yes.
stepfather. And then on the next page, she presses A and says, where did you learn it from? Now, up until this point, she's not described what it is she's seeing. And at first blush, you might think, well, the reader, knowing everything else we know about the case, might think we're talking about just kissing. So where did you learn it from? And she said, from Dad, and she explains it's the stepfather. So the officer says he wants to clarify. And at line 17, he asks her to clarify what it was she saw the child doing. And there we get the answer, touching her brother, putting the hand in his pants. Right, so that means, if we then take that information back to the start of the passage, where the mother describes what she's seeing, she is telling the police that she has walked in on one sibling, A, with her hands down the pants of the other sibling, and she has said, where did you get that from? And A has said, from my stepfather. So that is the mother's case to the police, a highly sexualized encounter between siblings, which is false.
Which is false.
It's false. The judge finds that the child did not do this. The judge finds that A did not do this. Yeah. She's not satisfied that's true. And therefore, it means the judge finds that the mother has given a false account and the stepfather has given a false account. And so then when one gets to the judgment of paragraph 147 and reads what the mother said about these matters, she said the only allegations she knew before January 22 were that stepfather and they had kissed, a video, and touching the bottom. And she said the mother denied that they told her the stepfather had behaved in a sexual way, shown her pornography, acted out what they saw in the videos.
So where are you reading from now?
About 5 lines up from the bottom of page 93.
Yeah, thank you.
She also denied saying that if the stepfather sexually abused her again, then something big would happen, or that she should not worry, or she will protect her. And the judge goes on then to find that the mother is wrong about that. So the significance of all of this is that very clearly, on the judge's permissible findings, this child was alleging sexual abuse in more than simply a pat on the bottom. And then to that, one has to add the judge's finding of the licking of the penis. And that is a finding that the judge was entitled to make, not because she just plucked that particular aspect of the evidence out of all of the evidence available to her, but because, as she reasons in her assessment, I think it's at paragraph 166, page 99. She sets out what happened at the trial, and this, again, to repeat myself, forgive me, is the phage advantage. This is the judge hearing the witness in the witness box one day, and then seeing him give his evidence the next day, and coming to the conclusion, as she does in this paragraph, that it was clearly something he thought about overnight. And she goes on to say that he clearly made it up. Well, she was entitled to that view. And that all comes from, amongst other things, the various discrepancies as between what the mother told Dr. P, what the stepfather told Dr. P, and what the mother told the court. And one can see, for example, the mother's evidence evolving.
Just before you leave the stepfather's evidence, at paragraph 166, can I ask you about a submission that was made on behalf of the mother before this court, which is that the judge was cherry-picking parts of the stepfather's evidence. So she found him not to be a credible witness. And so why is she suddenly latching onto this piece of evidence? One answer might be, well, this is contrary to his interests, so she's entitled to rely on it against him. But I think part of the complaint that's made is, well, she may be entitled to rely on it against him, but she's not entitled to rely on it against the mother.
Well, she has to determine whether the stepfather is what he's saying is true or not.
Yes.
So if she, however she reaches that conclusion, once she has determined that the stepfather is telling the truth about the matter, that is the fact that binds the mother and everybody else.
Yeah.
She does it. She reaches this because she sees him on one day say one thing, the other day say the other thing.
And it may be significant, the word unprompted.
Yes.
We've all been trial judges, and certainly speaking for myself, I often found that the most telling part of any witness's evidence was the thing that was said in passing.
Yes.
Which wasn't necessarily something that you were expecting them to say.
Which is why, as advocates, we're told sometimes to say nothing and to wait, and then the witness will say something. And here the witness said something unprompted, but that was against a background, as the judge, in great detail, in her judgment, sets out. He was taken through it by counsel for the local authority, exactly what he was saying about what had happened and when. And his inconsistencies are clear, but the mother's inconsistencies are also clear. And one can see, going back in the bundle on the judgment, page 92 and 93, that one sees at 144 the mother's case on what was observed of A with her siblings. And this too is the phage advantage shining through, and the judge spelling it out for the reader. She sees what the mother says under cross-examination by the local authority, and then she records what the same witness says on the precisely same issue, but when challenged by her partner's counsel on behalf of the stepfather. And then she records what was said when counsel for the guardian asked the question, which is effectively an amalgamation of the first two answers. So this is the judge who has the witness in front of her give one answer, in answer to one advocate, a different answer to a different advocate, and then tries to marry them up when the answers are shown to be incompatible in a way that's not convincing. as the trial judge, she was entitled to reject the mother's account about this. Not least because when one then turns on to paragraph 146, the mother gives an entirely different account. At line 4, she then tells the court that she had seen the child trying to kiss B, and that she saw the child with her hands in B's pants. And of course, the judge was entitled to contrast that evidence to the court with the account given to Dr. P, which was that this is something the stepfather had told her about. So this is the judge facing the only two sources of evidence, both of which are unreliable, but having to determine where the truth lies. And so it really, in our submission, does not sit easily in the appellant's mouth to criticise the judge for her attempts to untangle these various accounts and ultimately decide, in the light of everything she saw and heard, which account, in relation to which piece of information, she preferred. And in our submission, she's absolutely entitled to do that, absolutely entitled to come to the conclusion that this child had made serious allegations of sexual abuse that extended to the stepfather's private parts and what was said about that. And she was entitled, therefore, to reject the case of the appellant and the mother in both of those matters. She was entitled, as she did, to reject I might call them the defences that were raised by the stepfather. She was entitled to have no truck with his suggestion that he was touching A when he was seeking out C, for the reasons she set out, which she considers it. That's not to say that the stepfather has to come up with a reason, a credible reason for the allegation, but he has come up with an explanation. He hasn't said to the court, I don't know how this happened, or it never happened. What he has said is that this is what did happen. And the judge considers it and says why. It just simply did not stack up. And that was based on the evidence of the two informants, the two witnesses to those issues, mother and stepfather. She was entitled, as she did, to reject the evidence in relation to the video and how that just popped up on his telephone and how it was that A just happened to see it, even though, on the mother's case, A never sat beside or had anything to do with the stepfather, and the stepfather took a different point. He said that they were very close, they hugged routinely. So these were matters that the judge was entitled to reject, and she did so in rejecting them, without reversing the burden of proof. In relation, may I move on to January?
Yes.
22. In relation to January 22, the judge had, in fact, the benefit of two reliable witnesses, the police officer and the teacher. She found that both of those witnesses were reliable in relation to their notes. They were reliable adherents to the ABE guidelines in relation to those notes they took. Can I just deal then with the point that's made about the police officer and the summary as it's described? So the judge deals with this evidence at paragraph 71. Page 72. And it's important, I suggest, to have regard to how she is using that phrase, summary, or that word summary. What she says is that the officer told her, we know that she accepted what the officer told her, that he had his laptop with him, he followed his usual practice, made a Word document, and he said he described it as talking and typing. He typed a summary of what was said. He couldn't type every word the child said. So that's the summary that the judge is considering. It's not a summary broad brush summary. It's a summary in that not every word is written down. And whilst it's right to say that we do not have question, answer, if one does look to the entry at the officer's entry about this, which I think is, sorry, 259, thank you. Page 259 in the core bundle. There we do, in fact, actually either see questions or can pretty confidently infer what questions were asked. I asked A to tell me what had happened with her stepfather. So the question probably was, what has happened with your stepfather? She explained. I asked her to tell me more. So the question was, can you tell me any more? I asked her if anything else had happened. The question probably was, did anything else happen? Next page. I asked her about the chair. The question probably was, tell me about the chair. So, yes, we don't have the questions, and there are some references within that passage to 59 to 260 where we clearly don't have the questions. She clearly was asked about when she told her mother.
I think, if I've understood the criticism correctly, I think what's being said is that it's good practice to ask open questions, for example.
Yeah.
And if you don't know, if you don't have a good record of exactly what was asked, then you can't tell the manner of the question.
The judge found that open questions were asked.
Right.
It's fair to say that the form of the questions implicit in what he's written are pretty open.
Yeah.
To tell me what happened to his stepfather, that's a pretty open question. Tell me more.
Yes.
Can't get more open than that. Did anything else happen?
Yes. So they appear to be open questions.
Yep.
That chimes with the judge's finding. This was an experienced officer who knew his stuff, knew his guidelines, and applied them. That's her finding. That is an unimpeachable finding in our submission. And so she was entitled to say to herself, look, here I have actually a contemporaneous record, because he's typing as he's listening. But over here I have a very near contemporaneous record with DL, the teacher. Because what she sends to MASH is something that she wrote up soon after the event. And she also found that DL was an impressive witness who, again, would have observed the AB guidelines. So what the judge has then is this child, if the judge's initial findings in relation to the 2017-18 are unimpeachable or sustainable, then we have much similarity in what this child is saying across two very different developmental stages. The 7-year-old child A and the 12-year-old child A, saying things which are similar, and in some respects perhaps strikingly similar, about the licking of the penis. There is, of course, it's said there's a distinction in the venue of the abuse, but I think it's right to say that that may not be more than an omission by one party. So the social worker, her note talks about showing pornography in the living room, and then they go to another room, to the bedroom. The police officer, in his note we've just looked at, says that pornography was shown in the living room, and then says the child described the stepfather going on to abuse her. He doesn't refer to a move of room. That's not necessarily inconsistent with a move. It might be an omission from his note.
Or an omission in what A told him.
Yes. But that might be one of those submissions that the court is content to say the judge had well in mind if she did not traverse it uphill and down Dale.
I think it's quite appropriate, isn't it, for a judge to say, there comes a time when inconsistencies such as where did it happen for a 6-year-old, was it in the living room or was it in the bedroom, is neither here nor there. But some of the inconsistencies that are pointed out is the way that the allegation grows. So that accepting that there was evidence before the judge that would enable her to say that I am quite sure, sorry, I am on the balance of probabilities, I am sure that Mother did know in 2017, at that time, whenever it was, that this involved pornography, kissing, fellatio. By the time we get into 2022, it's become stepfather is fingering.
Well, November 22, and that's
yes, but it's the way that things progress. And one of the things I've been looking at is when you look at the threshold findings that were made, the judge in paragraph 218 says, looking at the threshold findings sought, I find them all proven on the balance of probabilities. I'm satisfied that the stepfather also showed A's penis and asked her to lick it when they were in the sitting room, whilst the father took a risk, etc., etc., etc. So, can you tell me, because I haven't located the threshold document, which is usually found in these papers. What happened about the talk of fingering? Is that something that the judge found proved?
yes.
Yes, it's 113 is the most convenient place.
Paragraph 5A little 2.
And so,
That
when did that happen? You see, part of the problem I've got is that I can see the force of your arguments in terms of what happened in 2017.
yes.
I can understand your submissions regarding the judge saying, and in 2022, all the child was doing was saying what had happened to her.
Yes.
But we then run into the problems about the continuing abuse, whether it was continuing or not. And we've got the issues about CL giving evidence that's not contained in her
Yes.
witness statements. And then you get the allegations coming for the first time in 2022 about digital penetration.
Can I deal with the way we would invite the court to
Yes.
look at that? The first point is that it's quite clear that the evidence of CL went well beyond the written material, and it would appear for the first time in oral evidence was as specific as it was. I mean, there are some references to it in the Dr. P report, but I don't think it's right to say that the level of detail is there. But CL has obviously nothing to do with 2017. CL has obviously nothing to do with January 2022. And her evidence is only probative aside from the 2017 and the January 2022, only adds to the threshold document that one line. It's an important line.
It is, and I just wonder, is the Guardian saying there are certain findings of fact that perhaps went too far, but the core ones are very much there and sustainable on the evidence?
Yes. So the Guardian is, sorry.
I was going to say CL's evidence really, from a lot of perspectives, was not satisfactory, was it?
No, it wasn't satisfactory. Part of the trouble, of course, is that because the judge deals with all the witnesses in a chronological order, it does take, as one who hasn't been before involved in the case, takes on a prominence that perhaps it doesn't deserve, appearing quite early on in the judgment, set out extensively because there's a lot of oral evidence set out. But in fact, what does it amount to? I think it's fair to say, it's probably fair to say that that finding is not specifically weighed in the detail that a serious allegation such as that might be. So we would invite the court to approach in one of two ways. This court has the powers of the lower court, and we would invite the court to leave that allegation as proven, but to do so on the basis of the material before it. And that is to start from the standpoint that the findings made by the judge otherwise are unimpeachable or sustainable, and therefore they happened. So that is pretty strong evidence. Secondly, that the judge heard, that TC and CL, perhaps not put too much weight on CL, and obviously TC comes with a bit of a health warning as well because of the complaints, which the judge is aware of. But it was open to her to say, well, the one thing I can take away from that is that this child described digital penetration. And then to add to that, what I began my submissions, or early in my submissions, referred to, and that is that police interview where the mother herself is saying that the trigger for the allegations was hands on privates.
Well, you then go into a full circle of the judge found that not to be correct.
Not to be correct, but that's not the end of it. What it is, it's the mother explaining why the allegations were made, what the allegations were.
The judge said it didn't happen.
No, that's right. But the mother was asking the court to accept.
But you can't have it both ways. If the mother's an unreliable witness and the judge finds her to have been dishonest in that description because she's trying to deflect what she did know, it's not fair, is it, to say then this court should say, well, forget what the judge says about that finding of fact, which is that the mother is dishonest about it, take it into account as support for an allegation of digital penetration, which, as you've conceded, I think fairly, perhaps has received the least analysis because it comes in the ether, as it were, floating in with blank playing quite a prominent part in it. And all that goes on. Wouldn't it be fairer if your submission actually was, well, all right, even if the court finds that to be questionable, the findings of fact relating to this sexual abuse involving the very serious allegation of fellatio should remain and is sustainable on the evidence, whichever way you look at it.
So my first submission is that the court can itself, notwithstanding the lack of detail that one would hope for, if the court doesn't find that it's there, reading between the lines, as it were, the judge hasn't set it out but had it in mind. If the court doesn't accept that, the court can do that and make that finding. But the second point is that the court otherwise can strike through that.
Well, hang on, there's a confusion. The court wouldn't make the finding. The finding has already been made by the judge. What you're saying is we should fill in the reasons that the judge didn't give.
Well, you have the powers of the court below. So you...
Yes, but we're not being asked to make any finding the court below didn't make. We're just being able... It seems to me the alternatives are either to retain it, and if we think the judge probably... If we're sufficiently satisfied that the judge had a good reason for making that finding, even if he didn't properly explain it, I don't think it's because of us exercising our powers. We would just uphold that finding and maybe say a bit in the judgment about why we were doing so. Or we would say there isn't enough, and we would strike out that finding. And that would effectively, though I don't know whether this language tends to be used in findings, in a sense that's merely striking out one particular. Yes. It's not actually I mean,
Remain.
it remains plenty of other instances of sexual abuse.
Yes. Well, not for the
You did
first-
use a phrase, but I think you may not used it. It may not come out as I understood it. We could leave the allegation as proved or leave as material before it. It's a phrase I didn't quite understand. That's not some piece of family law, LORE, there's something called material before the court on which we don't make a finding. Or is there?
No, I'm not. And I
No, okay, fine.
seek to establish
No, okay, good.
a line. Well, not for the first time, Lord. My true submission is better expressed when it's repeated to me. I'm happy to put it that way, that either the court upholds the finding, or if not, strikes.
Perhaps this is a time to raise something I should have raised earlier, which is a slight worry about this. It hasn't really been faced up to. If we dismiss the appeal, that's the end of the matter.
Yes.
If we allow the appeal on the basis that we're unhappy with aspects of the judge's approach or the judge's reasoning, then we have, if that's the only basis on which we do it, it would have to be remitted and reheard all over again, heard all over again. Unless, which would really be a completely different challenge, we would say it was take all this evidence, taking it at its highest, it was not open to the judge to make any findings of the kind that she did. Now, it's simply because you're on your feet, and when the point will come to the surface, it's really a question to check at the end of the submissions. But my understanding of the appellant's position is that they are asking us simply to to allow the appeal and not remit, which must mean they say that no reasonable judge could have reached this finding on this material.
Yes. That would be.
Does the Guardian have a position on that?
Yeah, I mean the guard.
I mean, you obviously have a position. Your primary position is we should dismiss the appeal.
Yes.
But if we allow the appeal, it rather depends on what basis we do it, I suppose.
Yes. Well, that's why on instruction, I am addressing the court in relation to the digital penetration issue, because it does seem to me that is something that, because of the nature in which it entered into the evidence, but because of the other evidence, as it were, is insulated from it, it would be permissible for this court to strike that, line through that. Yeah. But otherwise, I could not see how the court could come, well, the matter for my lord and my lady, but I think it would be a brave submission that no judge could come to a conclusion.
Well, Ms. Howe didn't explicitly make that submission in her oral findings, but it's there in her certain argument.
But that I think is why I wanted to spend a little time on 2017. And why in our submissions, our written submissions, we do take issue with the suggestion that the parents in some way are, their evidence is something of a bolt-on to the professional evidence, which is the evidence the court should really look at.
Now, I see the time, and I've now slowed you up a little. I don't think there's going to be much need for reply, but there'll have to be some. How much longer do you think you're going to need to be?
Not much longer. May I? I think there's just one or two matters. May I just check?
Yes.
If there's anything else? May I deal with two matters?
Yes.
Firstly, in relation to the failure to protect, what we do know is that the mother knew that A and the stepfather stayed apart from each other. What we do know is that the mother put a bolt on the child's door, the inside of the door, and no other child in the family had a lock on the door. And what we do know is that on the judge's finding, the mother, together with the stepfather, put forward explanations which were simply not true about the alleged sexualised behaviour of A as a way of either describing falsely where this had come from or simply misleading the court. So those are all matters which go to the question of fairness. Just then, if I may, in relation to the retractions, I think just one point, and it's go back to Lord Justice Singh's point in relation to 192 of the judgment. Can I just, I know the court took some time when it was referred to earlier to read that paragraph, but what's important, or what may be important to this court, in relation to the question about why it was the judge permitted to the officer the allowances that she did in relation to the first interview at school, but not in relation to the ABE. And the important point here is that the judge had the ABE video. So whilst it's important, of course, to know what an officer thinks about things, she really needs to know about what was said the day before, because she didn't have a video of that. She didn't have no evidence of demeanour. But what we can see here at 192 is how the judge deals with the issue of retraction and what strikes her in particular about the ABE interview. It's just a few lines and a few things that strike her in particular that she refers to, but certainly more than enough for her to explain why it was, notwithstanding that interview the day after, she rejected it as a reliable account. And that is, in our submission, sufficient detail for the judge to have set it out and for the judge to have explained why she, as the arbiter, took the views she did about that ABE interview and why she did not have to and cannot fairly be criticised for not deferring to or expressly attaching much, if any, weight to the officer's view about an interview that she could see for herself.
Are you making references here, for example, a number of passages in this paragraph where the judge says A was worried about certain things?
Yes.
Is that the kind of thing you're asking us to bear in mind? That the judge has been able to observe A in the video footage of the ABE interview?
Yes.
And is able to form a judgment about her demeanour?
Yes, and indeed it's that being worried is a throwback, as it were, to the January allegation, because if one remembers DL in her note, towards the end of her note on the MASH referral, as soon as she says, the child says, are you going to report this? The child becomes quite defensive and says, well, actually things are fine at home, it hasn't happened. This is a child who did not want the apple cart to be upset. She wanted things to stay as they were. This was not a florid account. This was a measured account. And that's why the judge was able to reject all those suggestions as to why the child had said such things as to rid herself of the stepfather from the home. But these are matters that she sees in the video, that are reflected in the papers that she's read and in the oral evidence that she's heard. And then she does finally deal with retraction more generally, I think, at 212. And can I just make one reference to the mother's police interview? There is the passage in her police interview. I think it should be 150 in the core bundle. And this is the mother's account about what she was saying to child A in November. And in our submission, if one reads what's at 150, there are 11 things that the mother, on her account, says to the child, which one alone a reasonable person would consider is likely to affect the child. So, number one, you're going to get your sisters involved in social services. Number two, no one will ever believe you. Number three, the police told you last time you can't say stuff to destroy somebody's life. Number four, so what you're saying is so big it's going to destroy somebody's life. Number five, you can't keep on saying stuff and then retracting them. Number six, it's not true. Number seven, I was so angry. Number eight, if you keep on saying this, you're going to lie, like into and out of the system, presumably the care system. Number nine, you're destroying your life. Number 10, I told her, you know, I need you to go, like a threat. Number 11, why are you not even sorry? Then grabbed her and shaved her head. So that is the evidence on the mother's own account of how she was in November. The judge was entitled to rely on that when she came to consider the retractions subsequent to the head shaving, and indeed in my submission, when she looked back to January 22 and asked herself, what was it like for that child that night at home with her mother, when this is her mother's own case, as to how it was a few months later. So the judge was entirely entitled to treat the retractions as she did. Ultimately, any allegation, the three questions I suppose are, what did the child say? What did the child mean by what the child said? And is it reliable? And that goes for an allegation and it goes for a retraction.
I think, Mr. Chairman, you really have reached the end of your time. Thank you very much. Anything in reply?
Just hopefully very briefly. I know that my lords and my lady have the point about CL's evidence, given as it was in the witness box. There was a complete lack of clarity in that evidence about the conversations that she had had with A in November of 2022, which, as we've established, were all unrecorded, but had a material impact on the judgment, as we see it, paragraph 209 of the judgment, where the judge relied on it to make the finding of fingering. If that allegation is unsound, we are still left with the difficulty that, as part of the exercise, A has made there's a complete contradiction in A's accounts between January and November, which simply isn't adequately dealt with. And that is where, on the one hand, A's allegation is of fellatio. On the other hand, in November, there is a clear and discrete piece of evidence that there had never been any exposure. So which part do you, as a judge, accept? And the judge simply does not deal with that adequately in her judgment, save for suggesting at paragraph 214 that TC's note may not be accurate, speculating, if I may say so, that TC may somehow have got that wrong, and then bringing into bear what has been brought to your attention as this oddity of accepting one piece of the father's evidence, the one sole piece accepted by the judge, was in relation to the timeline of when matters.
Really reply. Is this a reply point? How is it not just making a point again that you made before?
Well, I hope it isn't making a point I've made before. If it is, I will.
No,
stop.
okay. I just want. Yeah.
I suppose what I want to try to address is the exchange that you've had with Mr. Toomey about some of the allegations not being proved, striking some out or undoing those findings where the evidence is not sufficiently substantial, that doesn't resolve the other evidential difficulties. It means that the judge's overall analysis is left in a precarious position, because the one point that's made time and time again, and is a phage point and a very clear point, is that the judge takes the evidence as a whole. So the judge has not performed a sequential analysis of these allegations. She has taken on board all of the evidence of abuse to reach her conclusions and make her findings. If we start to undo one part of that by coming to the view that the evidence is unsafe or unsound, it is very difficult then to see how the judge's analysis can be left to stand, because the whole thing comes as a piece. So we would say if one part falls, the rest falls. To do otherwise is to unfairly parse the judgment. That's not to say, if you disagree with that point, that we don't encourage the reduction of some of the findings. Of course, that's a better than nothing approach, but we do say that does fall foul of the exercise, which is the judge's reflection on the evidence as a whole to arrive at her conclusions. Once some of that is flawed, it is...
Well, you have made that point.
Thank you. I'm sorry, I'm not repeating myself. The last thing you want right now. I think that's probably the only point I want to reply upon. And just, if I may, turn my back briefly to see if Ms. Fisher has anything else. Okay. And my lord, the only other thing was that in the course of our submissions, previously you asked me if I could identify where in our submissions below we have made references to lack of recording and inadequate recording. I've got a list, but would it be more helpful to email it to you and everybody else rather than dwelling on...
Probably would, yes, thank you.
Thank you very much. Then
thank you very much. Yes, Mr. Toole.
Thank you, my lord. Very briefly, the local authority and guardian submissions, however expertly presented, have fallen into the exact trap of which we complain the judge has fallen into. The local authority asks what was the judge to do with this evidence, and answers, the answer the local authority says, look at the credibility of the parents, not look at the credibility of the complainant, which is absent this judgment. My learned friend for the guardian at one point in his submission said there were only two sources of evidence that the judge had, and he meant the parents. Where does the complainant feature? And it is that imbalance that infects this judgment throughout. It is that absence of recognition of the retraction and active case of A that infects this judgment throughout and is continuing this afternoon in submissions. And finally, last point, Mr. Toomey's last point in relation to 150 of the mother's police interview. The list, I think he had 12 things, the list of you're destroying lives, you're saying and retracting it's not true, etc. And his point was the impact of a mother saying that in relation to the child. But if one looks at 150, it is you're destroying life by making false allegations. You're seriously impacting people's lives by making false allegations. And the timing of that interview is 10 months after the retraction starts. That interview is November 22, the retractions start in January 22. That is an approach that a reasonable, Section 31 reasonable parent, the objective reasonable parent might take. If you keep lying and making allegations, which the mother was being told by her daughter she was doing, you're ruining lives. And in my respectful submission, that is a point in the mother's favour, and that list is in the mother's favour as reasonable, not in the balance against her. Can I assist further?
Not as far as I'm concerned. No, thank you.
Thank you.
Thank you. Well, we're grateful to all counsel, both those we've heard from and those we haven't, and the solicitors behind them for their helpful submissions. We will be reserving our judgment. Draft judgments will be circulated in due course, obviously as soon as we can, and they will be obviously circulated on the usual basis which at this stage in the afternoon I'm not going to remind you of, but the principles as we found in the Counsel General for Wales case, they should only be shown to anyone other than those other than counsel to the extent necessary to fulfil the purpose for which they're circulated. Thank you all very much.
Thank you.
Court rise if able.